And so your marketing department has spun up a whole new campaign using an LLM that was unfairly trained, right? And so now all that content that your enterprise is putting forth as its new marketing campaign infringes a third-party copyrights, trademarks, trades. See what I mean?
Yep.
So, and we have no way of knowing that.
Hi, welcome to Tech Talks podcast. I'm Jeff Trent, the host today. I'm a solutions architect at InTime Tech. Guest today is Brad Frazer, a partner at Hawley Troxell and chair of the firm's intellectual property and internet practice group. Brad's work spans internet law, IP, and technology, plus the transactional and litigation realities that come with it. Brad is also a published novelist and a frequent writer and speaker on IP and internet law topics. So he's used to translating these complex legal ideas into language anyone can understand. I'm speaking with Brad today because our audience is building and deploying AI systems every day. And whether you're a founder, a freelancer, or a business owner looking to get into the AI space, the questions we're asking aren't theoretical anymore. Ownership, originality, disclosure, policy, and risk are all concerns to be worried about. Today, we're going to run a few real-world scenarios and get Brad's pragmatic take on how to think about them from the perspective of an IP lawyer. Okay, so I've seen you speak a few times, and I think, at the end, we'll definitely get you to kind of share more about ways to contact you and see some of your other work.
Oh, sure.
But in the presentations I've seen, you've had this not so little legal disclaimer in the fine print, and I think it just really sets the tone for the discussion we're going to have and how to kind of think about AI, especially from the perspective of a lawyer. I'm definitely not a lawyer, and I think a lot of the answers we might get to is going to be, well, it depends. We'll have to see how the case goes through the courts.
That's right.
So I'll just go ahead and read this. This is your words I'm reading.
Okay.
Yeah. So he says, legal disclaimer. It's all academic until I get sued. AI hallucinates and is biased. You cannot own Gen AI output. You get no indemnification. I almost got it there. From AI vendors. Your insurance probably has an AI exclusion. You cannot get patents on inventions made by AI. You cannot register a copyright in AI-generated content and thus cannot stop someone from stealing and using it for free. You cannot make warranties of title or accuracy as to AI outputs. Anything you enter into a prompt loses trade secret status and likely violates an NDA. When you scrape web content to train an LLM, you're committing copyright infringement. Your Gen AI output probably violates somebody's trademark, copyright, or right of publicity. And there's more if you want to contact Brad.
Yeah, that's a long disclaimer, Jeff, but that's a pretty good summary of the current legal environment of AI. It's a pretty good summary.
So we'll definitely post this. You'll see it if you're watching the video. But there's a lot of risks, I think, associated with AI that you don't think about. And I'm sure we'll get into this more, but when we think about risks, it doesn't necessarily mean you're going to get in trouble for it. You probably won't get in trouble for it right away, and things might change. But it's something that if you're a business owner, if you're in charge of using these tools, you really need to keep in mind because there could be some real consequences in the future.
It's true. And as you said in the disclaimer, it's all academic until you get sued. Let me expand on that, Jeff. Using AI is going to occur. And so the risks remain largely academic, meaning they're meaningless to you as a CEO or a CISO or a CTO. Frankly, they're meaningless to you until, one, you get sued, or two, you have to sue someone, or three, you go to sell your company, or four, you go to seek an investment round or borrow some money. In any of those scenarios, your level of use of AI dramatically affects those outcomes. But if you never, I'm the first person to tell clients, if you don't do any of those four things, then you can basically use AI with almost effective legal impunity without any real concern. But if those four scenarios arise, then I think we have to be aware of the legal environment of AI right now.
Yeah, I think that leads kind of the exactly to the first scenario that I want to, uh, come to. So I think it's going to be a bit of a role play, maybe a bit of talking about, just as me as different people, right? And I think the first one is I'm an entrepreneur.
Hmm.
Maybe I've been around for a couple years. I'm building a software product. Um, I'm looking for an additional round of funding, or maybe selling the company if if it's right. Um, and I have an interested party. They're looking. We've had lots of conversations, and now they're doing their legal due diligence and they're investigating my company so far. And what they find out is almost the entirety, at least 70% of the code that I've written for my software is actually generated by Gen AI. What they also find out is there's another company that was actually started by an ex founder that stole my product and is now trying to build it themselves, a
Hmm.
competing company.
Hmm.
So I'm coming to you, Brad. Maybe I'm this entrepreneur of this company, and I'm asking you, you know, what do I do? Um, can I go? Let's start here. Is like what actions can I take against this ex founder? That they seem to be devaluing my current company. I need another round of funding. I need to sell, and there's this, you know, huge black mark out there that is trying to take me down. Can I sue them? Do I
Right.
have any action against
It's
them?
a good hypothetical, Jeff, and it happens all the time, right? And so, one of the first questions I like to ask new clients is this as a thought experiment: what are we going to sue them for? We already know one of my favorite phrases is it's all academic until you get sued, which is true. But then the follow on question often is, Jeff, what are we going to sue them for? So, because unless you sue someone, their conduct is not going to change. True. You can, as to that bad actor, ex founder, you can send them a cease and desist letter. You can call them on the phone. You can do many, many things to try to alter their behavior. But candidly, in the real world, people don't change their behavior until they get sued. That's just true. I know that. And so we ask, what then will we sue the ex founder for? Okay, let's go through them. One, can we sue the ex founder for breach of contract? Do you have good contracts in place
He
between,
was he was there on the ground floor, right?
right,
Maybe there's some word of mouth there, but definitely nothing signed.
right, because that's how you do it when
Yeah.
you're a startup on a shoestring, right, with a founder. Nobody signs contracts. We have a suite of contracts that we encourage founders to sign to avoid this exact scenario. But you're right, Jeff. Well, let's assume here there are no contracts. Okay. Number two, can we sue the former ex founder for misappropriation of a trade secret? Maybe. Maybe. If the code base was treated as a trade secret and the ex founder has misappropriated and taken it, even without the copyright issues we're going to talk about, you can still perhaps sue for misappropriation of a trade secret. Problem with that is it's hard to prove something's a trade secret. Okay. Three, can we sue for copyright infringement? No. As we've talked about, and we'll talk about more, there is no current copyright protection for generative AI outputs. So if the founder or whomever, a disgruntled ex-employee, a former independent contractor, takes the entire code base, Jeff, that you're attempting to monetize now, there isn't anything we can do to sue them for copyright infringement, except as to maybe the 30% that was human authored, right? So you see that our odds of successfully suing this bad actor, ex-founder, are dropping with each question, right? It's
Yeah.
going to be harder and harder. This is why we always say that, you need to have a good legal foundation with your management team, meaning good contracts, protect your trade secrets, register your copyrights. So the answer, Jeff, is it doesn't look like there's a lot we can do against this bad actor, ex-founder. We can send them a cease and desist letter, but when it comes to actually suing them, we may have a hard time finding a big word, cognizable legal theory, right, to sue them for, to make them stop. So we'll do what we can, but my client has come to me with an unenviable situation, truly.
Yeah, got it. So I think you bring out some things, right? Like there is possibly some ways we could go after them. Maybe there is a trade secret there. Maybe there's something really innovative.
Right.
But I think even outside of that, there's not a lot that we can do.
No, there isn't. Not practically, because again, we can certainly send that original cease and desist letter. But one of my other practice pointers is if you're going to send a cease and desist letter, don't bluff,
Yeah.
right? Because if you say, I'm going to sue you and you don't, then you've lost all credibility. It's true. So in that initial demand letter, you'll have to demand that the ex-founder cease and desist and return all your intellectual property, whatever that may be. And if they ignore you, then you have to decide what to do next. And frankly, if you don't sue them, then you've really lost face.
Yeah. And like as a software engineer, the process I'm sure of going back into the history and finding every piece that was written by AI and every piece that was written by humans while a lawyer's, standing behind your shoulder is
Mm-hmm.
not an easy process for me either, right? Like
Right,
it's going to be a long, even if I did want to sue and even if I did want to try to claim that 30%, it's not easy. Like the amount of legal fees, the amount of time that my engineering team is going to spend
right,
trying to actually break that apart, especially, as a startup, how fast and loose we went from the beginning.
right,
So I think my 30% estimate from the beginning is probably likely going to actually be 10%
right.
that I can actually truly verify is human written.
Very good. And that's a good estimate. And the other aspect to that, Jeff, is that the 30% may be quantitatively accurate, but it may not be qualitatively accurate.
Mm,
Yes? Because what if the core functionality of your code is based on the compiling and operation of the AI authored source code? You see what I mean? What
yeah.
if the key functionality derives from that code base, the AI authored source code? That's what's compiled and run that gives the key functionality to your app. If the 30% is not qualitatively important, then our hands are tied as well.
Interesting. I guess that could go the other way though. Like,
Right.
if I'm just using AI to do the boilerplate stuff that we would say,
Right.
right? And the actual core business function is human authored, then I might have a better case of suing the ex founder in this
That's
case.
very good, Jeff. And in fact, I'm talking to my software clients about that very thing, which is given the current legal environment of AI and ownership, it makes sense to focus on the qualitatively important aspects of your source code and have that be human authored.
Yeah.
You can use AI to perhaps evaluate the code or bug check the code or write scripts that are effectively meaningless or just part of sort of the window dressing. But the qualitative functionality, if that's human authored, that really will serve you well later. It will.
Got it. Let's say maybe this is the case now, where we really looked at it. We have a really good case of, and the interested party sees it also of being able to close down this X Founder competitive.
Mm-hmm.
But what there's another issue that this interested party brings up is they still see that maybe a large chunk of the code base is still AI authored, and now
Mm-hmm.
they want to give me less money than I expected because they realize I
Right.
actually only own half or less of the product I said I owned. What's going on there?
Right. Another one of my favorite catchphrases as a lawyer is that if you have done this correctly and you have started your startup with foundational IP principles in place, and you go to have an exit and the buyer does this due diligence, Jeff, they will add a zero to the check if all the IP is in order. And I know that because I've done it, right? So conversely, if the IP is not in order and the buyer does due diligence, they'll take a zero from the check or they'll create the deal. Because as you said, why would a buyer buy something that does not imbue the buyer with a lawful monopoly?
Yeah.
You've heard me talk about that, right? A buyer wants to be able to buy a product that gives the buyer effective monopoly power in the marketplace. Now, sometimes that's not true. I'm going to be the first one to admit that there are things like the importance of brand, first mover advantage. A lot of those things give you a place in the market that aren't strictly IP related, strictly. But in my experience, the best way for a buyer to grab and buy and move forward with a lawful monopoly is to buy a robust IP portfolio. Okay, well, during IP due diligence, as you've suggested, Jeff, if the buyer determines that the source code, because this is a software company, was principally AI authored, a sophisticated buyer will pause and say, why would I pay you for something that I, downstream from this deal, cannot lawfully own and monetize
Yeah.
and stop people from using for free? It's a good question. And an entrepreneur like you, Jeff, should be prepared for that question from a buyer. Specifically that, let me say it again. Why, seller, Jeff, why would I buy an asset from you that you don't own and that I can't, downstream from this deal, monetize by stopping people from stealing and using it for free. That's the conundrum, right? And so unless you have a very good answer for that, the deal may absolutely crater if you have a sophisticated buyer. And more buyers are becoming more sophisticated in this space.
Yeah, for sure. So I think one thing that I can think of, right, with software, we see products that they open source freely, right?
Sure.
But they have services on top of the product. And maybe this isn't the case for maybe some hypotheticals, of course. But how valuable is having like a robust service built on a product that, you know, might be open source or AI generated? Is, that might be harder to replicate, harder to spin up.
Right.
Like, surely there must be some value now that I have as a company, because more than just the AI code, I'm building, these web services. I have, customer service reps already behind it. Uh, you know, other things set up that
Right.
lets the actual user use my software, more effectively.
It's a good point, Jeff. And what you're doing is you're building value in your company outside of your IP portfolio, right? Because you have human beings who are offering consulting services and providing services and installation services and bug fix or whatever, right?
Yeah.
So you're right. So if you've built, as an entrepreneur, a robust services platform that's maybe distinct from the source code or the other intellectual property aspects, then I think you still have something to sell. Absolutely. And a buyer will want to evaluate that when we're doing our due diligence, because many deals, I don't mean to digress too deep into the weeds here, but there are two kinds of deals: asset deals and stock deals. An asset deal means the buyer is just literally buying the assets, typically not the employees, typically not the hard assets, many times not a building or infrastructure. Many times they will just buy out the IP assets, right? A stock deal is where they buy the whole company. They buy the corporation and all the employees and all the liabilities. So depending on the nature of the underlying deal, it may be harder to package it up as a services deal if they're just buying assets, if you see my point. Okay.
Got it. Yep.
But nonetheless, it behooves the buyer to contemplate that and the seller to contemplate that proactively and think about, what do I have to sell in addition to my hard IP assets, or my soft, as we say, IP assets, particularly if a lot of my IP is built on AI. And if I may, just to go back to one of your earlier comments,
Sure.
Jeff, this is an important distinction. Let's make sure we understand that open source code is protected by copyright.
True.
AI source code is not. And so if a buyer were to balk because much of your code, and in fact, many of the deals that I do, the buyer will ask, how much of it is open source? That's a different question than how much of it is AI generated. We can absolutely own a copyright and enforce a copyright in open source code, not AI code.
Yes.
It's an important legal distinction. Yeah.
Yeah. Got it. Okay. There's one other thing that during the due diligence came up. They identified there's some risk with the product itself.
Right.
So the product that we're building is a custom generated generative AI tool for, making widgets or something, right?
Right.
And what we did to train it is we just went to the open web and, found pages related to widgets, and we just pull it in to build our tool. And they're saying there's possible risk that we committed copyright infringement. How does that hold up?
Right. Well, that's true. And for today, the legal environment of scraping is that a scrape, as they call it, a scrape, where you send bots out to gather data from the internet to train your large language model, no court has held that is a fair use, that's the copyright term, in all cases. There are some lawsuits in which a court has held that limited types of scraping, specifically the Anthropic case, has been in fact found to be okay. But we don't have a law that says wholesale scraping of internet content to train an LLM is a fair use, meaning that you're absolutely right, that if the practice of the company is to go out and wholesale scrape for free content on the internet without permission, without paying a license, means that you have, without more, committed copyright infringement. And just like the 65 lawsuits that are pending right now in the United States, those AI companies will get sued for copyright infringement. And they'll either have to pay or settle, like Anthropic did, or they'll have to have a judge say that, oh no, this is a fair use for all purposes. I do not believe any judge will ever say that, Jeff.
Yeah, that's such a big can of worms that
Right.
get opened up.
Right.
So the right way for me to do this then would be to go find all the sources, get a license for, or make them myself to train the AI. Have something internal only.
Yes,
Yeah.
that's right. If your company is going to either build or acquire a large language model, as you know, there are off-the-shelf large language models that you can simply license or acquire, or you can build one. If that large language model comes to you untrained, as it should, and you decide where to get the training data, you're right. The most risk-averse thing to do is to either go out and obtain a license to a known good data set, right?
Hmm.
It's called, the term is called fairly trained data. Fairly trained, the LLM needs to be fairly trained. That's the term. And that means that the owner of the LLM has gone out and either paid licenses to acquire that data, or, to your excellent point, Jeff, train it on known good data that's within the enterprise. Because your company, In Time Tech, has probably petabytes of known good data sets that have been generated by all of your employees from the beginning of time, right?
Yep.
All of that information is somewhere out there. And as you know, what AIs are very, very good at is analyzing and organizing and sorting and collating data. Right. So you turn an LLM loose on all of the accumulated In Time Tech data that you own, that you know is good, and now you have stood up a very valuable tool. That AI tool will be empowered with known good data. Now, what you choose to do with it in terms of your either internal use or monetization strategy are different issues. But you see what I mean? That would be the way, in my view, to minimize the legal risk of training an LLM.
Got it. Awesome. What other advice do you have for entrepreneur Jeff in this scenario?
Right. I would say that we need to be, well, because, Jeff, I'm an intellectual property attorney, perhaps you'll humor me and let me talk just for a moment about copyright law basics.
Yes,
May I
I
do
would
that?
love. Yeah, that'd be great.
Okay. My thesis as an IP lawyer is that companies want to make money, of course, right? And they don't have a pure socialist, kumbaya, open source motive behind their business practice, that they want to be capitalists, frankly, and that they want to monetize their business either by selling goods and services or having an exit. That's the typical model.
Sure.
Okay. One very valuable part of that is an intellectual property portfolio
Yep.
comprised of copyrights, patents, trademarks, and trade secrets. My principal job is to help entrepreneurs like you, Entrepreneur Jeff, to build an IP portfolio that will add a zero to that check for your exit. That's what I do. Okay. Now, if you have chosen to use artificial intelligence as part of your value proposition to create things that you're going to seek patent protection on or copyright protection on, it will undermine the value proposition, because today in the United States, and in frankly any foreign country, you don't own that intellectual property. Why is that? Let me explain that, and I'll be brief, but let me try to explain that. Okay. First, copyright is a noun, not a verb. We don't copyright things. In the United States and all the other B-E-R-N-E, Berne Convention countries, copyright is a noun. Specifically, Jeff, when a human being reduces a sufficiently creative idea into or onto a tangible medium, a copyright, a noun, is created without more. You don't have to pay money to the government. You don't have to put a Circle C on it. You don't have to mail it to yourself. When you, Jeff, take a picture of your dog, you have created a copyright. Period, full stop. Okay, we start there. So when human beings author source code, copyright law calls that a literary work, specifically, and a copyright arises at the moment the source code is written by the human being, either owned by the human being or by the human being's employer. That's called the work for hire doctrine. Okay, so now we know how to amass a body of copyrights. We cause human beings, employees typically, to write code or take pictures or write books, right?
Yep.
Or make movies. That's how a media company creates a portfolio of copyrights. Human beings create creative works. There you go. Now we own all those copyrights. Great. But Jeff, how do we monetize them? The next step is to take all those copyrights that we own and register those copyrights with the U.S. Copyright Office. That is the law in the United States since 2019, to be able to sue someone for copyright infringement and think it through. Isn't that how you monetize a copyright? Having the ability to sue them to make them stop? Otherwise, what will human beings do? What will bad actor human beings do, Jeff? It's not a rhetorical question.
Steal it.
They'll steal it and use it for free.
Yeah.
right? So to make them stop, we have to have this thing called a registered copyright. Again, that's the law since 2019. Okay, now let's pause there. We own a copyright by reducing a creative idea to a tangible medium. 1. 2, we want to sue people to make them stop so that we can monetize our IP and have a $10 million exit. Great. Okay. 3, to do that, you have to have a registered copyright. This is where the wheels come off the bus. When you file a copyright registration application, you have to swear under penalty of perjury that the work is a work of human authorship. You see?
Yep.
And you can also become more granular, and because of recent Copyright Office pronouncements, you can delineate how much of the thing that you're seeking to register the copyright in was human authored and how much was AI authored. And you have to be accurate in that assessment. Because if later in court, when you sue somebody based on that registered copyright, trust me, the defendant will examine that issue. And if you have misled the Copyright Office by misstating the amount of human authorship, your case will be dismissed. You'll be made to pay the other side's attorney's fees, and your ability to monetize the copyright goes to zero. That's how copyrights are monetized. So the wheels come off the bus, Jeff, with the AI construct because you can't properly represent under penalty of perjury to the Copyright Office that it's human-authored code or human-authored movie or human-authored book, you see? So we extrapolate not just from source code, but to any media.
Yep.
And the value proposition of that asset goes to zero. Why? Because you can't sue anybody to make them stop stealing it and using it for free. There it is in a nutshell.
So I'm going to point people to your other work. So we'll make sure, stay tuned, listen to the end so you can hear Brad in other places. But I think the natural question is like, well, I put in the prompt, so isn't it mine anyway? I don't want you to answer that.
Okay.
I want people to look at
Okay.
and ask Brad online or wherever
Sure.
for that answer. Okay.
It's a good question, and that is the appropriate follow-up question. Yeah.
Okay. I want to go to the next scenario.
Mm-hmm.
If we're good to go there.
Sure.
So the next scenario is I am the Chief Information Security Officer, the CISO of a medium to large size organization, let's say like 250 employees. About a year ago, the CEO saw how cool and fast AI is, Gen AI is, and encouraged all the employees to use it. And now maybe I just listened to this podcast with you, Brad, and I'm like, oh, there's some risks I don't know about. And I do an analysis, I check to
Right.
see what everyone's using it, and I realize that a good portion of nearly every department in the organization has been using Gen AI for everything. And maybe we make widgets and we have a software app that also like lets people organize their widgets. And I discovered that developers who have our storefront website have been using generative AI for like the last 2 years.
Sure.
And now the app that we've had around for 10 years to help people organize their widgets, for the last 2 years, nearly every single line of code has gone through like a generative AI.
Yeah.
But it's more than just software. It's the marketing department's using it for their ads. The legal department even is using it for their contracts. Internal memos are being written with it. Press releases are being written with it, at least partially in all these cases. For nearly the last year, it seems like there's few cases where I can find a piece
Right.
of generated work that
Right.
didn't have AI touch it.
Right.
So
Boy,
I'm going to come to you and I'm like,
sure.
what do I do?
that is the status quo, right? You have now just defined the
Yeah.
status quo in America and most other industrialized nations relative to the use of AI. There is a lot of unregulated rogue use of AI, just like you've described. Companies don't know how to control it. There are no real, and I hate to use this buzzword, guardrails around the use of generative AI. Companies try to adopt and promulgate AI usage policies, and most do. I'm sure you have an AI usage policy. I've written several, right? The challenge, though, of course, is constraining that rogue use, right? Because it's 5 o'clock on a Friday. The CMO has just marched into the marketing department and told all the interns that we need a whole new marketing book by Monday. Well, what are you going to do? You're going to turn to AI. You're going to turn to Midjourney and Grok, and you're going to come up with it. Okay, great. So on your hypothetical, when you discover those facts, there is unadulterated, unrestrained, unguardrailed AI rogue usage in your enterprise. Remember, what did I say at the very beginning, Jeff? It's all academic until you get sued, right? Or what? You go to sell your company,
Yep.
or you go seek an investment round. So you may be, forgive this I'm not going to use this expression, you may be oblivious and happy and unaware of those risks for 20 years.
Yep.
Because you never get sued, you never have to sue anybody, you never seek an investment round, and you never sell your company. Those are the times where the wheels come off the AI bus, right? Okay, but let's assume one of those things happens.
So, okay, I want to ask another
Okay.
question, scenario here, which has happened before.
Right.
We're using this in marketing tools,
Right.
and AI hallucinates.
Sure.
And, maybe it put out something. Maybe we have a chatbot on the website, and it's telling about discounts that aren't real, or it's having some wording
Of course.
that customers are finding loopholes
Sure.
with. How beholden are we as an organization to?
Oh no, you are forming contracts. You are out there forming contracts without all that content. Sure you are. So let me answer the question this way.
Sure.
Rogue AI usage, as you've described it, has two concerns: inbound and outbound. And by that I mean the inbound issues are, as we've discussed, we don't know for sure where the LLM was trained. And so thus the outputs very likely, as you said in the very beginning, reading that disclaimer, the outputs that your enterprise is using may contain otherwise illegal content, infringing content, images, trademarks, copyrights that you don't own. And so your marketing department has spun up a whole new campaign with using an LLM that was unfairly trained, right? And so now all that content that your enterprise is putting forth as its new marketing campaign infringes a third-party copyrights, trademarks, trades. See what I mean?
Yep.
So, and we have no way of knowing that because you don't get, as you said in the beginning with my disclaimer, the AI company doesn't warrant that those outputs are accurate.
So, okay.
Right.
So I guess
that's I'll let you proceed, but that's the inbound issue. Inbound, we don't know how and where the LLM was trained. Oh, so we don't know how good the outputs are. Okay. The outbound issues are, to your point, you cannot make warranties of accuracy as to any of those outputs, right? Because you don't know how and where the LLM was trained. So to your very good hypothetical, what does an enterprise do when it has discovered rogue AI usage like that? Well, it needs to analyze it from those two perspectives. Let's look at all of our outputs and determine how bad it is if we get caught and sued. No kidding.
Yeah.
And let's look at our contracts and see if we are making outbound warranties as to these outputs. A software company who has had an AI generate its code cannot warrant that it owns the code. It cannot warrant that the code is error-free or bug-free because it doesn't know. See what I mean? Inbound and outbound issues.
And once again, back to the beginning.
Right.
It's academic until you get sued.
Right.
So like companies could hold on to these risks for 20 years.
Sure.
Until, it blows up.
Right.
So, okay. I think, so another scenario, I guess, part of this, right, is I might, as part of the marketing team, generate a new ad campaign, using Gen AI and get sued, even though, it's generated by AI. I would think that would be public domain maybe, but it's, using maybe this, cartoon character from like the 70s that no one's heard about.
Right.
And, it looks a little bit different, but it's just, it's nearly there, right? So am I still beholden to potentially this trademark breach, trademark usage, unauthorized trademark usage, even though it's this Gen AI that was, didn't you just say like the output's public domain? So I'm not really owning it either now, right?
You're right. Are you familiar with one of the AI lawsuits? It's Disney versus Midjourney by any chance?
I surface level understanding,
Okay.
yeah.
There are at least 70 pending copyright infringement lawsuits in the United States against AI companies. One of the most illustrative of that point is called Disney versus Midjourney.
Yep.
Disney sued AI image generation company Midjourney. During the course of preparing that lawsuit, Midjourney's lawyers went out and entered multiple prompts into Midjourney and caused it to spit out identical images to Moana and The Little Mermaid and the whole Disney portfolio. So there you go. That's Exhibit A. Literally, it's Exhibit A in their complaint, right? So the fact that Midjourney spits out Moana and Midjourney gets sued for copyright infringement, Moana's not in the public domain. Moana is highly protected intellectual property owned by Disney, right? See what I mean?
Yep.
And now that liability flows downstream. So if you had used Midjourney, if you, Jeff, had used Midjourney to create a marketing campaign, and your marketing interns had no idea who Moana was, for example, or
Sure.
the little princess,
Yep.
and you use that Midjourney output in your marketing campaign, you're of course going to also get sued by Disney. You see, that's the problem. It all flows downstream from the original act of infringement, which was the original scrape. All true.
Can I in turn then, maybe I get sued now from Disney.
Right.
Can I go now in turn sue Midjourney?
You can. Very good, Jeff. But the problem is, remember, what was one of my first questions? What are we going to sue them for? Remember that? You remember that academic question?
I think in this case it'd be a breach of contract, right?
But
Because
it wouldn't be, because Midjourney has given you no binding contractual warranties as to the accuracy of those outputs. So you come to me and you say, I've been sued by Disney for having Moana in my marketing collateral. I didn't know who Moana was. I'm a cranky old white guy. I didn't know who she was. Okay, well, you go and you want to have relief against Midjourney. Midjourney made no contractual promises that you weren't going to get sued. So then you say, well, then I've got insurance. I'm going to go invoke my insurance policy. Are you? Are you, Jeff? Go read the exclusions in your liability insurance policy, and I'll bet you lunch that there's an exclusion that excludes AI output. Why? Why would an insurance company, Jeff, not want to underwrite AI outputs? Why? Because they can't. What do underwriters do? What's the underwriter's middle name, Jeff? Quantify. An underwriter cannot quantify that risk. So how will I ascribe a premium, Jeff, to an unquantifiable risk? You can't. See what I mean? And so it just goes on and on and on like that.
Got it. Okay. So, staying in this hypothetical, there's all these different departments using it. I think we touched on marketing. That's maybe a high risk. If you're making promises to customers, if it's visible, if it's going outside your doors, that is something that is high risk. And I'm going to want to have a much closer look at that as a CISO.
Right.
What about software? Maybe we don't have a lot of competitors. Maybe it's hosted internally and we're just, displaying the website. So all of the AI generated stuff, most of it is internal anyway, right? We don't have a lot of risk in that way of, Gruntled ex-employees stealing it. We have enough services built upon it. It'd be, do you see a lot of risk maybe in that scenario for medium-sized business to use AI there?
No, I don't. I think you've described a good AI use case, in fact. And if the enterprise insists on using generative AI and it's aware of this legal environment in which it's all academic until you get sued, but once you get sued, it's a bet the farm kind of a thing, right? I mean, if you get sued and lose one of these $100 million lawsuits, unless you're very well funded, it will mean bankruptcy for the company, right? Okay. But what you've described, using known good data sets to train your internally hosted LLM and only using the outputs internally and only using the code base that's generated internally for maybe, an internal operation system or a manufacturing line, an assembly line or something, those are good use cases for AI. It's when the generative AI outputs go outside the enterprise that we increase the odds that you're going to get sued. That's just true.
Got it. Okay. I want to talk about some other use cases here also, right?
Sure.
For like internal emails, internal communication, maybe even some light external emails, using a Gen AI to, help me write better. Is there risk involved there? Is that
you're doing a good job in this continuum, Jeff, moving from a low risk case and now we're adding layers of risk by saying, all right, what if we use an AI tool to help our employees write better customer facing emails? What are the risks there? One, we know we will not own any rights in that email, meaning literally that a bad actor can take your email from your employee and place it on social media and mock you. And you'll have no legal recourse. Think about that. Think about that. Have you ever thought about a bad actor using outputs from your company on social media to mock you because somebody in your customer service department sent an AI-generated email and they put it on TikTok and mock In-Time Tech because you sent out an email which is mockable, right? But if you had copyright protection in that email, which you otherwise would, there are all kinds of tools we can use to get that removed from the internet, right? But now you do not. And that email mocking your company remains on the internet forever because you have no tools to remove it. See what I mean?
Yeah, that's interesting. And, as like someone who's on the internet a lot,
Right.
you definitely see like people putting bad reviews of stuff.
Right.
And even if, it is fair use, the first thing that they always get hit by is copyright claims.
Sure.
And if you're
If the
taking,
thing is
yeah,
AI generated, we can't. It's called a DMCA copyright strike.
right.
DMCA, right? You can't do that. But what are the other risks? Well, if the AI has been trained on bad data, and the email that has spun up, to your point, bad prices, bad warranties, right? Bad representations, you're all contractually bound to that
Yep.
because your agent, your employee sent it out as an official company missive, and you've now created a contract, Jeff, based on an erroneously generated AI document. So there are all kinds of risks with that, right? So what do? Do you have every email read by a human being before it goes out? Sure. But see, now you've killed the value proposition in AI because you're doubling the workflow time.
Yep.
See what I mean? But we can continue that exercise. What else? What if we use AI to write our code base and it does go outside the company? We've already examined that. What if we use AI to write a marketing campaign that goes outside the company? We've already examined that. So the more that our AI usage touches the outside world, Jeff, we are exponentially increasing the company's risks. Risks that you cannot mitigate with indemnification, because Midjourney doesn't indemnify you. OpenAI doesn't indemnify you. Microsoft, despite its much ballyhooed promises, does not indemnify you for Copilot, right? I've read it, and they don't, right? See what I mean? And so what are you going to do? Go to your insurance policy? Maybe. Go read Exclusion 37. You see what I mean? So this is the legal environment in which companies are operating. And I understand that everybody's excited about it, and they're all probably just going, well, let's make as much money as fast as we can, because as Brad said, it's all academic until we get sued. And if we never get sued, we're all going to get rich, and we're going to have a big payday. And then by the time the wheels come off the bus, we'll have retired to Belize, right? I mean, no kidding, Jeff. No kidding.
That's what I'm betting on.
Yeah.
Okay, I think there's one more area here that I want to touch on is like internal legal usage. I said like the
yeah.
lawyers are
Right.
even using it to write maybe employee contracts or the
Right.
employee handbook or things like that. That feels risky, but it's not necessarily external. Maybe you can kind of go help me on
Sure.
how I should evaluate that risk
Sure.
of some of these documents.
I do not use AI to practice law. I could. I absolutely know how to use AI, right? But I don't use it to practice law. I use it to do other things, but not practice law. Here's why. I have a kind of a three-step analysis that I use when I advise clients on using AI. One, if it's a bet the farm kind of a case, use a human being lawyer, and have your in-house lawyers use human being lawyers too. Be human beings who are creating the work. Because bet the farm, you don't want to go to court and have incorrect citations to cases or incorrect citations to law or unenforceable contractual provisions because the AI didn't know. Okay, number one. Number two, if it's just sort of an average level legal exposure deal, sure, have humans use AI and have humans look it over. Three, if it's just an average workflow where Jeff says to the legal department at Anytime Tech, hey, I need a talent release for Frazer to sign when he comes to do the podcast, right? Well, that's fairly low risk. Okay.
Yeah.
So you have to determine the nature of the use, right? If it's a low risk proposition, then I'd say, sure, have AI write your contracts and write your boilerplate terms and your terms of service and your privacy policies on your website. Sure. Remember, though, that I personally, Jeff, have handled cases where a client has come to me and said, I want to sue these guys for breach of contract. And I read the contract and I say, with all due respect, new client, John Doe, who wrote this contract? Because it's not enforceable. Right? See what I mean? And so, well, an AI wrote it. And I don't want to be demeaning or rude, but I'm going to say, you have tied my hands. You have tied my hands, because when I ask that rhetorical question, Jeff, that I'm going to ask, what are we going to sue him for? The answer is nothing, because the contract is unenforceable. See what I mean?
Yeah.
So if there's any chance that you're going to have to sue somebody over this contract, a human being needs to write it. No kidding. At least today. Now, I'm not going to give any names, but some purveyors of AI tools say, oh no, we've solved all that. We give you warranties against malpractice and we give you warranties. Well, that's fine. But remember, it's all academic until you get sued. So you have to determine what your risk tolerance is to getting involved in a lawsuit. Because what's the real exposure in getting sued, Jeff? What is it? Is it losing? No, it's the attorney's fees.
Yeah. Yep.
Right? So you may go to court and win, but you may still have to bankroll that and pay $500,000 in attorney's fees, right? So anyway.
Yeah, and I think with that, it's just the time that it takes a lot of the time. Like if
Right.
you're legally obligated to pause doing something for 2 years or however long for the case to settle,
Right.
then you might be even if everything else was handled.
So that's called human capital cost, right?
Yeah.
So take the $500K you're going to pay your lawyers. Take the $500K you might have to pay the other lawyers, and now run a 5x multiplier on that
Yep.
for lost human capital. See what I mean? That's why it's all academic until you get sued. That's when it really becomes important.
Okay, I want to hit on one more question on this scenario.
Sure.
And maybe this isn't quite your expertise, but if we're using Gen AI tools and we have a product that maybe healthcare related HIPAA concerns,
Mm-hmm.
or just PPI, identification for people that we're supposed to keep secret, or control, but we're feeding into Gen AI that's hosted on a third-party server somewhere, right? What are the risks that we're seeing there?
Oh, that
Or
is
how do we
you-
make sure that we
wow.
can provide that service?
You could not have crafted a worse hypothetical in terms of legal risk. Well, as you said from my disclaimer, whatever you enter into a prompt loses its trade secret status. It just does.
Yep.
Why? Because you don't have contractual obligations of confidentiality unless you have typically paid for it. Sometimes the subscription versions of an AI will provide confidentiality as to those prompts. But have you read the terms of service? Probably not. And so my general rule is that what you enter into a prompt loses its confidentiality. We start there. By extrapolation, then, if you enter PII into a prompt, you've violated HIPAA. Sure you have. Or PHI, rather, personal health information. PHI would violate HIPAA. PII would probably be looked at as a data breach. Think about that. Every state has a data breach law. And if it says that your PII that you are responsible for has been exposed in a manner that after a reasonable due diligence investigation, there's a chance of misuse. Think that through. So I enter, arbitrarily 100 records of PII, employee PII into an LLM, a public LLM. I have now violated all those state data breach laws.
Yeah.
Because that PII is now subject to misuse. Why? Because the LLM uses it to train the LLM downstream. Yeah. It's now in the public database. See what I mean? So that's a tough situation. So the only thing we can really do is encourage employees, train them, and enforce a policy that says we will not enter PII, trade secrets, or company confidential information into a prompt. There you go.
Now as a CISO, is there anything I can do now? I've seen that it happened. I've looked at the prompts.
Right.
Can I, call up, OpenAI and say, hey, get rid of these prompts from these users? Like, what options do I have now to?
Right. Well, not many, except to rectify it immediately and ensure that no confidential, trade secret, PII or PHI is being entered into prompts anymore. And then you really cannot call the AI purveyor and say, hey, I erroneously entered some confidential information, please delete it. One of the main reasons, Jeff, is because, as you perhaps know, in these many, many, many copyright litigations, courts have ordered the AI companies to retain all that data, retain it legally.
Yeah.
So every single prompt you have entered into OpenAI from the beginning of time is still sitting out there. They cannot delete it under court order, right? Think how nice that is for the lawyers, because now I can go out. Let's assume I'm suing you. You're a former employee, Jeff, right? And I'm suing you for misappropriation of a trade secret. Think this through, right?
Yeah.
I'm going to send a subpoena to ChatGPT, OpenAI, Microsoft, right? And I'm going to say, give me all of Jeff's prompts, or using your IP address or whatever, and they're going to look through and go, well, look at this. Here are all of Jeff's prompts because we had to keep them because the court ordered us to keep them. And they send those prompts to me, and son of a gun, Jeff, those prompts contain my company confidential information. Boom, I win the lawsuit. You see how powerful that is?
Okay, yeah. So with this, is there a correct way of doing this? If we were building something and we do want to, put some, customer information, maybe even, PHI through a system, one thing that we talked about was, paying the extra cost. Maybe there's a
Right.
contract there. We
Right.
know it's confidential.
Good.
Do we still need to disclose to our customers that, there's this, transfer of their data more than maybe we would, with the typical usage of hosting things, in the cloud under controlled confidential environments?
You've asked an important question about disclosure of use of AI. That's something we haven't touched on. And interestingly enough, that is the only aspect of AI usage that is currently regulated.
Okay.
That's the only one. There are no federal or state laws that govern the use of AI. There are at a very granular level in California and Illinois and other places. But in general, Jeff, there are no overarching federal laws relating to the prohibitive, proscriptive, or permissive use of AI. The only laws that we really have right now about AI usage relate to disclosure. And every state, including Idaho, has laws relating to the disclosure of use of AI. So depending on the state in which you're operating, and you operate in all 50 states, you may indeed, Jeff, have a legal obligation to disclose the use of AI. You may. It will depend on that state's statutes. In Idaho, I just know coincidentally that in Idaho, if during a political campaign, specifically
Yes.
a political campaign, right, you use any sort of deep fakes, you have to disclose that as part of the campaign. Well, that's a very arcane, granular example, but I bet you lunch that California laws are not that granular, right? So bottom line is, don't know, but I would look at the laws in which you operate, the laws of the states in which you operate relative to your obligation to disclose the use of AI. On those facts, indeed, Jeff, you may have an obligation to say to your customers, hey, we've entered your PHI into a public LLM. That may be required under the laws of that state. Absolutely.
Okay. Awesome. Okay. Anything else? Any other advice that you have for a CISO or, someone from the C-suite looking at AI use in a medium-sized company? Any risk that we haven't touched on that you want to highlight?
I think that I would encourage a CISO to work with his or their legal department and do a complete review of your outward-facing contracts, really, because this discussion today, Jeff, affects every contract your company has.
Yeah.
It affects your privacy policy on your website. It affects your non-disclosure agreements. It affects your employee contracts. It affects your independent contractor agreements. It affects your SaaS subscription agreement. For example, let's assume that you are, as everybody is now, an AI-powered SaaS platform, right? Everybody.
Yeah.
Everybody is AI-powered SaaS. I don't mean it mockingly. Everybody's an AI-powered SaaS platform. Yay, go SaaS, go AI. The problem, though, is that your SaaS subscription agreement that you're using to sell these subscriptions to your AI-powered gizmo probably violates some state law because you're not fully properly disclosing within that document your use of AI. I don't know. See what I mean? Or you're not properly safeguarding their confidential information because you're entering it into a public LLM or whatever. See what I mean? So my advice that we haven't spoken of yet thus far would be, if you're a CISO, I would work with your legal department to review all of your customer-facing contracts for AI usage. Specifically, let's review what the list is. 1, disclosure obligations. 2, warranties of title. Can you warrant that you own it? No. 3, warranties of accuracy. Can you warrant that the outputs are accurate? No, you cannot. You have to disclaim those warranties. 4, IP ownership. Can we use these outputs and go to court and make someone stop using our stuff and make them pay us? See what I mean? That's all an integrated analysis, and much of it is contractual.
Yeah.
And by that, I mean, for example, let me give you a quick example. You should have independent contractor agreements. Most companies, most large enterprises, including In-Time Tech, use non-employee independent contractors. Of course you do. You have an independent contractor agreement with that human being. That contract should, as of 3 years ago, should say specifically, independent contractor represents and warrants that they will not use artificial intelligence in generating the deliverables. Why? Because without that warranty, you won't own that work product, and you will have paid for something that you don't own and that you cannot create a lawful monopoly in. See what I mean?
Yeah. Well, you stole my third scenario there. Just
Oh,
right
did
now,
I?
Brad.
Okay,
A
well,
little
that's all right.
bit.
We can go back to it.
I think, yeah, I think this is great. I think every company that has lots of customers, medium large size business
Yeah.
needs to look at their contracts that they're putting out, and
Yeah.
and if they have not updated them in the last 3 years, it needs updated.
Agreed.
Awesome. Okay, so let's move on to the third scenario, and you just touched on it a little bit. But the third scenario is I'm a freelancer. I work for myself.
Right.
I have maybe a client list, and I'm being a little bit vague. I want to touch on one question I want to touch on is, does it change if I'm using, I'm designing a website, I'm making music, I'm, building a program, like does the type of creative work used by Gen AI change the legal outcome of it? So, well, I'll ask that question in just a sec. But anyway, I'm a freelancer. I have some clients. Maybe I've had them for a while. Some of them might be some small businesses. Some
Mm-hmm.
might be just be individuals.
Right.
Maybe like I do some work on Fiverr for just like individuals doing stuff. Um, and for a long time, I've been doing this my freelance work. And before Gen AI came out, I did all myself. But now I'm starting to use Gen AI a little bit. And I've kind of had a policy. A lot of this is smaller stuff. There's not a lot of contracts that are written. Maybe some blanket something I got off wherever for free, or maybe I'm using like Fiverr or another like contracting website or whatever, and
Mm-hmm.
they probably have contracts also.
Right.
Um, now I've started using Gen AI sometimes if I feel like it's a good use case. And, what is the risk that I have now
Mm-hmm.
of not disclosing that? My policy is like, don't ask, don't tell here. If someone asks, like, I will tell them, but otherwise I'm happy to deliver the product that they're wanting and, use Gen AI or not. So
Right. Oh, so my new client is a freelancer.
new client, freelancer.
Okay.
Yes.
So fundamentally, we have to ask what state is the freelancer operating in? Some states, as we've just discussed, have disclosure obligations. In fact, last year, in the last legislative session, there was a bill that didn't get passed, but it was introduced requiring exactly that,
Mm.
requiring that all use of AI be disclosed. How about that? That's not the law in Idaho today, unless it was enacted in this session, but I'm not aware of that. But other states probably do have a statute like the one that was tried to be enacted in Idaho that says if you use AI, you have to disclose it. So, number one, what state is the freelancer operating in? Okay, number two, before AI, here's how it worked. A freelancer, a human being who created content, created and owned a copyright in that output automatically and for free. The only way that that human being independent contractor, Jeff, was divested of that copyright is if there was a signed contract, independent contractor agreement, stating specifically that the contractor assigns the copyright to the company.
Mm.
Short of that, the independent contractor owns all the copyrights. So when I give a copyright law presentation to a group of independent contractors, there's this epiphany. And I say to them, do you realize how many copyrights you now own because your company that engaged you didn't have you sign the appropriate contract? And suddenly there's this look of epiphany, like, oh my gosh, I own that logo, I own that code, I own that software, I own that photograph. See what I mean?
Yeah.
And now they're thinking, oh my gosh, what am I going to do with this bit of empowerment? Am I going to go sue my former client? Sure, you absolutely can. You see what I mean?
Yeah.
That's the power of that underlying contract between you and the first question answer to the freelancer is one, what state are you operating in? Two, what's the contract structure you're operating under? Right? If you're a freelancer, why in the world would you ever offer a contract that automatically assigns to the copyright your client? Make them ask for that. Good grief, right? And is that unethical to say to a freelancer client, hey man, you own the copyright, make the client ask for it in assigned writing? I don't think that's unethical. I think that's good business practice. Okay, three. Now, that situation changes, of course, when the independent contractor is using AI, of course, because the outputs are not owned by anyone.
Right.
And so it becomes a fiction for the contractor to say in a contract, I, independent contractor, assign to In Time Tech all of my right, title, and interest to the deliverables. That's a fiction because there's nothing to assign. Does that make sense?
Yeah.
So we have to look at it from that perspective. So I would say to an independent contractor client, what state are you working in? What are the laws relative to disclosure? Two, are you authoring this stuff as a human being? Are the deliverables human authored or AI authored? Three, what does your contract say about that? because the independent contractor might think, hey, I pulled one over on this company, man. I did all this code, but there was no copyright assignment. I own it. And I would say, well, no, because AI wrote the code.
Right.
See what I mean?
Got it. Okay. I thought this one might be shorter. Anything else? We've talked a lot of topics. Anything else that you'd give for advice or risks for the freelancer using Gen AI in their...
For the freelancer, no, but I would be careful. I would, one, be aware of your legal environment. Two, I'd read all contracts carefully, because even if you're using, you might think, I can pull one over on the company. I'm going to use AI. I have nothing to assign, so I'm certainly happy to assign whatever I have. The problem with that is that the company might come back and sue you for either fraud, think about it,
Yeah.
fraud, or some kind of breach of warranty. Because if I hire a coder as an independent contractor to come in and write a whole new software program to automate my robotic system or something, right? Well, there's an underlying assumption that deliverable I will have rights in. Even if the contract isn't specific, I think that I would go back and sue the independent contractor for fraud, frankly,
Right.
or a breach of contract, and say, or there's a thing called the breach of the implied covenant of good faith and fair dealing, and say, hey, independent contractor, I paid you $500,000 to write code to run my robotic system, used AI, I don't own it. Now my competitor is using the exact same code base, right? And I'm angry at you, contractor. That's not a bad lawsuit.
Right.
Not a bad lawsuit.
Once again, it's all academic.
It really is, and
yeah.
I hate to keep beating that drum, but it really is true. And so we come full circle to this issue, and maybe this is what we end on. All of this is an issue fundamentally of what? Risk tolerance.
Yep.
So if you have a C-suite who is inherently risk tolerant, and they have good insurance, and they have a $300 million cash liquid war chest, right? And they're willing to go to court and bang that drum, great, more power to them. But if you don't have that environment, if you don't have a risk-tolerant C-suite, Jeff, if you don't have a $300 million cash war chest, if you don't have great insurance, if you're not fully aware of your legal environment, then you must be less risk-tolerant relative to AI. You simply have to be. So fundamentally, all of this devolves to a question of how risk-tolerant is your C-suite.
Yeah.
That's it.
Got it. Awesome. Thank you for the conversation. I've really enjoyed it. Maybe you can plug yourself on where else people can find you and hear more about what you do and hear more of your talks.
Sure. Well, again, Brad Frazer, Frazer. I'm a partner at a law firm in Boise, Idaho called Hawley Troxell. And it sounds a little silly, but it's true. I think because of my social media presence and my publications and everything that I've done, I really think that if you just went out to Google and entered Brad, B-R-A-D, Frazer, IP lawyer, I think you'd find a lot of my content that way. No kidding.
Awesome. Great. Okay. I have a couple questions.
Sure.
I always like asking my guests at the end. What keeps you up at night? What are you excited about? And what worries you? Let's start with what worries you. There's a lot of things changing. Of course, we're talking about AI.
Right.
It's relatively new. There's a lot of AI doomerism. The world's going to end. And I think, a lot of the people I've talked to are tech professionals. So, we have our take, but I'm definitely interested in some of the concerns that you have, just in the world. And once again, it doesn't have to be AI. We've talked about a lot about AI, but, there's other things going on as well.
Sure. I have to let my answer to that question be colored of the lens of copyright law.
Sure.
I have to. And so, interestingly enough, Jeff, one of my concerns was answered this last week.
Oh.
And it's this. I had been concerned about the effect on the economy of a court decision holding that AI outputs could be protected by copyright law. Could be protected by copyright law. Because suddenly now we have a market that is flooded with AI outputs.
Yep.
Flooded. There's no human inventorship required or authorship, right? And so now we are flooded with, and I don't mean the term pejoratively, but AI slop is what they call it. And so now all of that stuff is protected. The courts are flooded with copyright infringement lawsuits and copyright demand letters and copyright trolls sending demand letters. And it concerned me that there would be this adverse economic effect if a court held that copyright AI outputs were protected by copyright. because we would flood the market with all of this AI generated stuff.
Yeah.
And what would that do to think of the humans affected by that. Think of all the human coders and graphic artists and screenwriters, and see what I mean?
Yeah.
The economic consequences, the human consequences of that decision would be, I think, catastrophic. If you follow through the consequences. Court holds AI slop is copyrightable. Copyright means that I can now monetize it, protect it, sue to infringe. I don't need human inputs at all, right? The human element needed to have a copyrightable work is now zero.
Yep.
See?
Yep.
But thank heavens, within the last 2 weeks, the United States Supreme Court, SCOTUS, did a very specific legal procedural thing. They denied cert in Taylor versus Perlmutter. Let me unpack that.
Yes.
I hate that word unpack, but I'm going to use it. Well, here's what that means. A guy named Stephen Taylor filed a copyright registration application on an AI-generated piece of art.
Okay.
I think it's called Darbus, something like that. Anyway, it was a picture, a very nice picture. It's a very nice pastoral picture scene. It looks a little bit like a watercolor or maybe an acrylic, but an AI generated it from Taylor's prompts. Okay. He sent the work into the Copyright Office, fully disclosed that it was AI generated, fully disclosed, but he wanted to have a registered copyright in this picture. Copyright Office said no. That's their job, is to say no. Okay, now, this is an important point, and we didn't talk about it. The Copyright Office, counterintuitively, Jeff, doesn't decide issues of copyrightability. Isn't that funny? The Copyright Office does not decide copyrightability.
Okay.
They make an initial determination based on your application whether this is copyrightable subject matter. That's not the end of it. Like Stephen Taylor did, if the Copyright Office says no to your copyright registration application, what do? You sue the Copyright Office. Perlmutter, she was the director of the Copyright Office at this time, right?
Interesting.
So Taylor sues Perlmutter in federal court, asking a federal court to declare that this AI-generated work of art was copyrightable subject matter, right? Okay, and I was watching that case every day. That's what kept me awake, thinking, oh no, if Taylor wins and Perlmutter loses and all this AI slop gets protected by copyright law, think of the incredible effect on human capital.
Yeah.
Why would we have human beings do anything ever again? You
Yeah.
don't have to, right? There would be no reason legally. Okay, so Taylor lost at the trial court level. Taylor appealed it one level up to what's called the Court of Appeals. The Court of Appeals said, no copyright for you, Stephen Taylor, in your AI output. No, because you got to have a human being.
Yeah.
Okay. Taylor appealed it. He tried to appeal it to the U.S. Supreme Court, SCOTUS. Okay. Now, before the Supreme Court hears any case, they have to grant this thing called certiorari, cert, right? If the Supreme Court doesn't grant cert, then the underlying appellate court decision remains the law of the land. Taylor appealed to the U.S. Supreme Court, SCOTUS, and they denied cert, meaning they said to Taylor, we're not going to hear your case. The underlying appellate court decision denying copyrightability to AI outputs, it remains the law of the land. This was in the last 2 weeks. This is one of the most foundational, to me, remarkable decisions that we've seen ever since the advent of AI, because now we have some clarity for the moment that AI outputs are not copyrightable. True, that's the law of the land. And so everything we've talked about today, Jeff, gains completely new relevance because it's true that these AI outputs that you're building your company on are not protectable at copyright law or patent law. And so I ask again rhetorically, where is the lawful monopoly that you're going to try to sell to your buyer? It doesn't exist. There it is. And so now I sleep better because Supreme Court, SCOTUS denied cert in Taylor. There's the shorthand version. Brad sleeps better now because SCOTUS denied cert in Taylor. There you go.
That's great. Okay. So you were worried about that.
I was.
You're not worried now.
I'm not.
Anything else that you're worried about?
Not today, but it's only, what is this, Thursday? I mean, give me a few days,
Well,
Jeff.
it's not the first time a court's changed their mind.
Yeah, that's true. That's true. So it'll be interesting to see what happens. But for the moment, at least I have a little bit of repose that the law of the United States remains that all those graphic artists and coders will at least have an argument they should be keeping their jobs.
I on that level, I agree, with you 100%. But, there's a lot of very influential tech billionaires that definitely want laws to go one way or the other, and they have the resources to
Well, sure. Well,
push one way or the
was
other.
it Amazon that fired 14,000 people or Meta? Somebody filed. Yeah. Okay.
Yeah.
Well, so let's think that we're going to save a lot of money and fire all these human
Yeah.
beings. What is Brad going to say to that? It's all academic until you get sued. Because when you go to court to try to stop somebody from stealing your stuff, and it turns out in court that because you fired 14,000 employees, that thing that you're litigating was generated by an AI, case dismissed, and I can use it for free.
Yeah.
So there will be consequences to those decisions.
Sure.
It may take a while, but there will be legal consequences.
Well, unless they do change the regulations around that anyway, and
Maybe because of the power of the billionaire lobbyists. But I think
I'm definitely glad that from what I've seen and talked to you about that, legally things are going around AI the way that I'm hoping for. There's the guardrails in check. There's still a lot of things unsaid.
Sure.
But,
you know where it stands today, Jeff? Here's literally where it stands today. And everybody should be happy about this. The law today allows for and contemplates joint human AI authorship.
Yeah.
And we come back to a point I made earlier. As long as a company is resolute about making sure that qualitatively, that aspect of its outputs are human authored, that will solve a lot of your problems. You can see why. So use AI to do the menial grunt tasks of checking code or error checking code or writing, linking libraries or whatever. But when you get to the qualitative meat of the source code or the movie or the book, have a human do that.
Yeah, that's great. And I really love that. And you've said that for yourself, right? You're a human that does law. You don't let the AI do it.
I do not.
And, for a developer, for a programmer, I think that's, for the core business logic, doing that as a human. And all the other
Sure. Well,
boilerplate.
I don't mean to, I'm not going to be deceptive. I ask legal questions to AI all the time.
Sure.
But I don't copy
Yes.
copy and paste that into an email to a client.
Yeah.
Right? Sure.
Okay. So what are you excited about? What's going on? It could be in your life, could be, in law or, just wherever that excites you, that you're happy about, that you're looking forward to.
Well, it sounds funny, but it's true. I like to practice law, and I have been very blessed to have an area of practice that I find academically and intellectually stimulating. And so as funny as it sounds, I look forward to continuing to practice intellectual property law and watch the law evolve as we're seeing all these changes brought about by artificial intelligence. I'm very blessed and very lucky. I have a wonderful, healthy family. I have a great practice. And so I guess I would just say I am pleased and blessed to be in a very fortunate circumstance relative to 99.9% of the rest of the world, And that really is true.
Yeah. Well, thank you, Brad. It's been a pleasure again to have you on the
Jeff.
podcast.
Thank you.
It's been great talking with you. Thank you. This is, Brad Frazer from Hawley Troxell. If you want to hear more about him, talk to him, you can Google Brad Frazer, IP lawyer.
It really is the best way. And Jeff, because I was on this podcast, everybody who's listening to this podcast gets at least a 30-minute free initial consultation. How about that?
That's a good deal.
Yeah, it really is. And I'm happy to do it. So don't be shy about reaching out.
Okay. Well, thank you.
Thank you, Jeff.
Thanks for watching this In Time Tech podcast. If you'd like to learn more about what we can offer you, please visit our website, intimetech.com, where you'll be able to see the different capabilities and technologies we could provide you in your business. Also, don't forget to subscribe and follow us to get more amazing content like this. Thanks again, and we'll see you next time.